the basic structure doctrine could stand in the way of a wholesale switchover to the presidential form of government. It's not that the court freely applies the doctrine. You can call me a qualified and chastened critic of the doctrine.
On the 50th year of the basic structure doctrine that requires the court to review and restrict Parliament's powers to amend the Constitution's foundational principles, we speak to the former Additional Solicitor General Raju Ramachandran, who was once a critic of the doctrine. Basic structure doctrine was evolved by the Supreme Court in the 1973 landmark ruling in Keshwananda Bharti vs. State of Kerala, which said that the basic structure of the Constitution cannot be amended by the Parliament.
On the 50th anniversary of the Keshwananda Bharti ruling, we are with Senior Advocate Raju Ramachandran to discuss what the doctrine means and how it's relevant for today. Ramachandran is a former critic, is that right to say, sir? A former critic of the doctrine?
You can call me a qualified and chastened critic of the doctrine.
So, what is the basic structure doctrine's relevance today?
Today, the basic structure doctrine, which I have criticized on grounds of pure theory, is the only safeguard against amendments to the Constitution, also with politics becoming increasingly presidential in style. The basic structure doctrine could stand in the way of a wholesale switchover to the presidential form of government.
When you say it is the only sort of check against majoritarian impulses, so to speak, there is a view from within the government and others who think that this is something of a judicial invention that is so vague and amorphous that it can never be applied objectively. Is that true? What is the basic structure then?
There's no doubt that it's a judicial invention. I mean, on the face of it, it is. And it does depend on the subjective perception by judges of what the basic structure could be. And when you go back even to the Keshwananda Bharti case, you notice that different judges of the majority, in their enumeration of basic features, there are differences. So the differences start from there on perception. But I must say, 50 years down the line, the imperfections of the doctrine have not led to the judges running amok. After all, ultimately, the number of cases after Keshwananda Bharti where constitution amendments have been struck down is only 6, while in those very 50 years which have intervened, there have been about 76 amendments to the Constitution. So it is not, firstly, that every amendment to the Constitution gets challenged. And even if it's challenged, it's not that the court freely applies the doctrine. And therefore, the apprehension that the political class is prevented from carrying out important changes which they think may have the popular backing, those apprehensions are not justified, because even those few instances when the court has intervened, let's remember, have all been cases where, in the context of judicial review and independence of judiciary, that's where the court has intervened.
Yeah. because like you said, in most of these cases where the court has partially or fully struck down the constitution amendment, it has been something to do with taking away these legislations, taking away judicial review.
Yeah.
How do you see that? Is that a limitation of the basic is that a limitation on how the court has applied the basic structure doctrine? Because we are not talking about other features at all. Or is that a good thing that the court has so sparingly used it?
No, it is definitely a good thing. Because after all, as I have argued, conceptually, it's an anti-democratic and counter-majoritarian doctrine. And when I use the word majoritarian, I use it in a different sense from how you would normally understand majoritarian. I mean the will of the people as broadly expressed through the people whom they vote into power. So, considering that, the court has been very restrained, and if the court takes the view that the independence of the judiciary and its powers of judicial review are non-negotiable, no one can seriously have a problem with it.
Would you tell us what is the basic structure as we understand? Because what we keep hearing is that there are, a number of things that the courts have over the years have enumerated. It is not it's still an inclusive list. You can add more things, take away more things. So how do you define the basic structure?
One can define it only if one thinks within a narrow compass and then looks at the basic of basics and not get into other aspects which ultimately may be matters of detail. According to me, the basic of basics would be sovereignty, which would also then mean, for instance, if there's an organization like the European Union, if India were to be part of a regional economic union of that level, then there could be a challenge on the ground of sovereignty. So that's one basic feature. Then a republican form of government as against a monarchy would be basic. Secularism would be basic. Democracy would be basic. But then a moot question would be between a presidential form of government and the Westminster system. Is there a major difference? I think there is, because the Constituent Assembly made a conscious choice in the context of the accountability of the executive, where the parliamentary form afforded a greater degree of accountability on a day-to-day basis. So within the democratic system itself, parliamentary versus presidential can pose a problem. And even within the parliamentary system, suppose we move from the first past the post system to a system of proportional representation. Would that fail the basic structure test? That's a moot question. That's a moot question. But I would think that these are some of the very broad basics.
And then the details would really depend
That's
on
right.
The issue at hand.
That's right.
Like we discussed earlier, you were once, you still have criticized this. Like you said, it is antithetical to a counter-majoritarian.
It is counter-majoritarian in nature. And that power is exercised, after all, by unelected judges. And that's something which the judges also need to caution themselves. And I must say, to their credit, considering the few instances where they have interfered, that is also at the back of their minds when they apply the doctrine.
So the foundations of the basic structure is what you had critiqued earlier.
Yeah.
What is the difference now? What is the qualified criticism now that you have?
Let me explain that, and I think I should. It was in 2000 when the era of strong majorities seemed to have decisively ended. So, in that context, I felt that the days of brute majoritarianism were over. Major political decisions and major constitutional questions would henceforth be settled only through consensus. And so, 50 years after the Constitution, the country should be given an opportunity to put the economics, the lessons of economics and politics into practice by amending the Constitution in whatever way the political class thought fit. But even then I had argued that the basic structure doctrine, in spite of its conceptual inelegance, had served a purpose in the context of the emergency, Mrs. Gandhi's election case. It reminded a still fledgling democracy of the perils of brute majoritarianism, and that those days are over. But 23 years after that critique of mine, we seem to be back to the era of overwhelming majorities. And so, it seems that that doctrine acts as a protection. And I'm sure you'll agree with me that 23 years is a long enough period in a person's life for him to say that he has lived a bit, he's learnt a bit.
What new facets of the Constitution, that are basic structure, that you see come up in litigation now in the future?
Now, if you look at the CAA case, that would involve issues of equality and of secularism. If you look at the challenge to the watering down of Article 370, it would raise issues of federalism. So, straight away, in respect of two pending cases, you have three facets of the basic structure which are important.
Thank you so much, sir.
Thank you. Pleasure talking to you.